State of Wisconsin, Circuit Court, Branch 1, Manitowoc County. State of Wisconsin, Plaintiff versus Stephen A. Avery, Defendant. Pretrial, Case Number 05-CF-381. Date, February 2nd, 2007. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances. On behalf of the State of Wisconsin, Special Prosecutors Kenneth R. Kratz, Thomas J. Fallon, Norman A. Gahn. On behalf of the defendant, Dean A. Strang, Jerome F. Buting. Attorneys at law. Stephen A. Avery, defendant, appeared in person. Transcript of proceedings. Witnesses, Sheriff Gerald Pagel. The court. At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05-CF-381. We're here today for a final pretrial conference in this matter. Will the parties state their appearance for the record, please? Attorney Kratz. Your Honor, the state appears by Calumet County District Attorney Ken Kratz, appearing as special prosecutor. Also appearing as special prosecutors include Tom Fallon from the Department of Justice and Norm Gahn from the Milwaukee District Attorney's Office. Attorney Strang. Good afternoon. Stephen Avery appears in person. Jerome F. Buting of Buting and Williams represents him, as does Dean Strang of Hurley, Burrish, and Stanton. Attorney Kratz. Judge, I'm sorry. Before we proceed with our agenda this afternoon, I had alerted the court that I was going to make a technical change to the information. That's been done to a 4-count information as represented on Monday. I am prepared to file that original with the court. Mr. Strang has already received a copy. The court. Very well, you may give the clerk the original at this time. There are a number of items for the court to address today. The first one I have on the list is the state's motion for release of blood vial evidence and blood spot cards for scientific testing. Who's going to be speaking on behalf of the state? Attorney Gahn. I will, Your Honor. Attorney Strang. Your Honor, if I may, before we get to that, the defense acknowledges receipt of the second amended information because actual objections to the jurisdictional and otherwise have been raised. I preserve those. We appear, especially to that extent, not waiving objections to the second amended information, but acknowledge receipt of it and waive reading. The court. Thank you. Mr. Gahn? Attorney Gahn. Thank you, Your Honor. In our motion that we filed, we are asking the court to release the vial of blood that is currently under seal in the clerk of court's office here in Manitowoc County. The defense has filed a response, and that response levels allegations that we are trying to try this case by ambush, or at the minimum, trying to be cute. The court. All right, let's stop right there. Because if the defense has filed a written response, I don't have it. When did it come in? Attorney Buting. Yesterday. The clerk. I don't have it. The court. Check with Robbie. Was an original filed with the clerk? Attorney Buting. Yes. The court. The clerk is indicating she doesn't have it. Attorney Buting. I have a copy and with the attached exhibits. We faxed that. It says it was received. The court. All right. At any rate, I have a copy at this time. And I trust, Mr. Gahn, from your comments, that the state has a copy. Attorney Gahn. I'm sorry, please, Your Honor. The court. I trust from your comments, since you made response to the defendant's response, that you have a copy. Attorney Gahn. Yes, Your Honor. The court. All right. I now have one, so you may proceed. Attorney Buting. Do you want to take a moment, Your Honor, and read it first before we proceed? The court. Just a minute. All right, I have a copy of this document, but I didn't understand that this document referred to the blood vial evidence. Attorney Buting. Did I give you the wrong one? I gave you the wrong one. The court. All right. Mr. Gahn, you may proceed. Attorney Gahn. Thank you, Your Honor. I would like to just recap a little bit the chronology of events and what brings us here today. On December 6th, we were notified that this vial of blood existed in the clerk of court's office. And on January 3rd, we filed our motion to exclude blood vial evidence, or in the alternative, would the court grant continuance for us to allow us to test that vial of blood. By written decision and order on January 9th, this court denied our motion for the continuance to test the vial and reserved ruling on our motion to exclude the blood vial evidence. The following day, on January 10th, I was informed by law enforcement officers who were involved in this case that they had received a call from the U.S. Attorney's Office. And the U.S. Attorney's Office had expressed concern over the decision not allowing us time to test this vial and offered their services, shall we say, their pool or whatever, to expedite testing that we would like to see done with the resources available to them, namely the Federal Bureau of Investigation. At that time, we made the decision that we would like to see what your ruling was, because we felt that we had a rather compelling and powerful argument for the court to rule that the blood vial does not come in. And so we waited for your decision on that issue. And we also felt that we were in a good position and felt that that decision was likely because the court had denied our motion for continuance. In any event, the decision came down last Tuesday, and the court has decided that the evidence of the blood vial is going to come in this trial. The court ruled that although we found the probative value rather low for this evidence, I think the court based its decision upon the Sixth Amendment right of the defendant to present a defense, and we understand that. But the court also noted in its decision that the court would entertain any request by the state to test that blood, should we wish to pursue that. And that is precisely why we're here today. We're going to ask you, Your Honor, to unseal that blood, and we would like to send that off for chemical testing and what other tests that we deem appropriate. Some of them, it's difficult to say how we want to test it because we don't know the condition of the blood yet. And until that blood is examined and just determine what shape it's in, that will determine what test we will pursue. But we will be able to pursue the testing for EDTA, which we originally asked the court to give us the continuance. And we are told that the FBI will have that testing completed before the close of the trial. I think that speaks to the vast difference in influence that an assistant district attorney from Milwaukee County has with the FBI lab and the U.S. attorney. But we're told that that can be accomplished. I would ask the court to reconsider the thoughts that the court put down in its decision about the Cooper case. There are some vast differences with the situation that we have and that Cooper case. And I would ask the court to recall that in my argument, I thought that I laid out those differences well. I thought the Cooper decision was brought by the defense. It was a post-conviction hearing. And up until now, I could not find a decision where the state brought a request for EDTA testing. It's generally brought by the defense. And in that case, they simply had stain samples. And the individual, the person, the lab that tested those were claiming that just the mere presence of EDTA in the sample, therefore, indicates it came from a vial of blood with EDTA. I agree that there were some stretches made by the defense in the Cooper case, but this case is different. We have standards to compare to the EDTA levels, if there are any, in Teresa Halbach's SUV. We have the vial itself, and we also have standards that are at Laboratory Corporation of America. And this makes this a vastly, vastly different situation than what the Cooper case presented. And I believe that the testing that would be done in this case we would clearly clearly meet the Wallstadt standard here, and that whatever issues the defense has would go to the weight of the evidence and not to the admissibility. Because even a reading of the Cooper case, all the experts agree that the underlying scientific principles, the ability to test substances for the presence of various chemicals, is well established and has been for many, many years. We believe that it's critical that we be given the opportunity to test this vial of blood and present those results at trial. I believe that the testing that we will be able to accomplish before the trial is over will clearly show that the blood in Teresa Halbach's SUV did not come from this vial of blood that is in this building. Now, the defense does not like the case of State versus Kunkel, but unfortunately for them, it's the law. We have the right to meet their defense in rebuttal, and we really don't have to tell them how we're going to do it. But we're telling them today how we're going to do it, and they take their chances if they are going to go down this planting defense at their peril. The defendant's response to our motion for access to the blood vial evidence, in a way, I think strongly supports our position that we be given the opportunity to conduct the scientific testing. If the court would look on page 6, paragraph 4 of their response, the defense intends to use the vial as an exhibit and to bring it into the courtroom. And they state that they want to have it as an exhibit in court and display this and any alteration of the condition of the vial. They talk about the amount of liquid, the condition of the top, in order to demonstrate the viability of the defense that the vial was tampered with by officers. And then they state directly, or through agents, what concerns me here is that this is flying right in the face of your decision to allow the blood vial in. But you did place limitations on how far they can go with this planting frame-up defense. Who are the agents of these officers they are talking about? And it seems that we are now back with bailiffs in this courtroom, clerks, anyone who works in the Manitowoc County Clerk of Court's office, maintenance personnel, anyone who had a key to that office, anyone who had the combination to the second door that you get in. All these people now seem to be, could they have been the agents of one of these deputy sheriffs? Furthermore, to bring this vial into court and show it to the jury, to show the amount of liquid, the condition of the top, you are now again, this seems to fly in the face of what your court order was in your decision to place limitations. Do we now have to call the North Carolina people to see how they put the stopper on? The nurse, the phlebotomist that took the blood out into this vial? Into this vacutainer? Is that why the hole is in the purple top? The information and the exhibits to the defendant's initial motion to seal this evidence indicates that the box was crushed in transit. Did that cause, perhaps, the stopper of the tube to be dislodged ever so slightly? These are just questions that we're going to be going off on, that I believe was not the intent of the court when it rendered its decision. But more importantly, if they are allowed to bring this vial into the courtroom and start discussing quantity, how much is in it, whether the stopper tube has been tampered with, or whether there's been a breach by a needle through the top, you are getting into now scientific matters. And you are going to be looking at the jurors, the color that's there, the viscosity of the blood. There are so many. Now we're getting into areas that it cries out for chemical testing. If this is what their intention to do, they are basically bringing in science into the courtroom about the vial of blood, and that is not correct. This can only be answered by testing this vial of blood, giving us the opportunity to test it and show the defense and show the world what this defense is, that these officers would plant blood in Teresa Halbach's car. We have to have that opportunity. The minute they bring that vial in, we have to have been given the opportunity to test it, Your Honor. I'm concerned for the Halbach family and Teresa Halbach that they get the trial that they deserve. But also, just as importantly, I know from 22 years' experience as an assistant district attorney and 10 years in law enforcement with the Criminal Investigation Division of the United States Army, I always know that there is always can be a tension between the police and the prosecutors. But the relationship we have is embraced by each other. And when two officers are accused of what they are being accused of, for the last week, these two deputy sheriffs have been on the broadcast news and on the print media and painted as if they could do something like this. And as a prosecutor, we have a responsibility to do everything we can to also restore their good names. These deputy sheriffs have protected this community. They put their lives on the line. They get into situations that none of us want to deal with in life. They are both good, solid, decent family men. They are kind men. They are gentlemen. I'm sure everyone in this room knows them. They deserve to have their reputations protected. And we can best do that by allowing us the opportunity to test that vial of blood and show the world that the blood that is in Teresa Halbach's car did not come from this vial of blood. In the Wisconsin case of State versus Migliorino, 489 Northwest 2nd, 678, they quote from the United States Supreme Court, and they state that absent a constitutional provision statute or evidentiary rule to the contrary, the law is entitled to every person's evidence. As former Chief Justice Warren Burger emphasized, for a unanimous Supreme Court, the need to develop all relevant facts in the adversary system is both fundamental and comprehensive. The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence to ensure that justice is done. It is imperative to the function of courts that compulsory process be available for the production of evidence needed by either the prosecution or by the defense. And that's in United States versus Nixon, 418 U.S. 683, 1974 decision. And a few years later, in United States versus Robinson, at 485 U.S. 25, 1988, the Supreme Court stated, "The central purpose of a criminal trial is to decide the factual question of the defendant's guilt or innocence. To this end, it is important that both the defendant and the prosecutor have the opportunity to meet fairly the evidence and arguments of one another. And for us to meet fairly, the allegation that these two deputy sheriffs, these sworn officers who have taken an oath of office, would do something so despicable and so criminal necessitates us to have the opportunity to show how incorrect and untrue and vile that allegation is." That's all I have, Judge. Thank you. The court. Mr. Buting, Attorney Buting. Well, Judge, it seems to me we're having nothing more than a rehash of the state's previous motion, which this court considered thoroughly and denied for good reason. We object to any testing at this time other than fingerprint testing. We say that we have no objection to the state bringing in some fingerprint analysts to examine the vial, as it is, in the clerk's office. But we do object, as I say in my response, at this late 11th hour, to any opening of the vial and doing tests on the vial of blood itself. If this motion has been filed long ago, it may be different. If this motion had been filed long ago, it may be different. But one thing that Mr. Gahn left out of his chronology here, They were notified, by the way, December 6th, that was 2 months before trial, that this blood existed. And no motion was forthcoming at that time, no EDT motions forthcoming. And I'm not usually in the habit of reading people's emails in court, but it wasn't one sent to me in any event. So I think the court needs to recognize that in the crime lab records is an email dated almost 1 year ago, February 6th of 2006, to the crime lab analyst. And at that time, a year ago, this email demonstrates the state was aware of and considering the possibility of EDTA tests. It says, quote, Norm agreed that the blood stains, or a couple anyway, should be tested for EDTA preservative to deflect the absurd suggestion that cops are carrying around vials of blood. I know your lab doesn't or can't test for it, but Norm suggests the lab of hygiene might. Do you think that's a good idea, or should we go to a private lab? 1 year ago, they knew about this potential EDTA test, and I don't have the answer to that particular email, but the answer is that they didn't do it. And they didn't test it because they were afraid they would find EDTA in the stains in the RAV4, and that the defense would have another argument that this was planted evidence. That's what's going on here, Judge. Just to make clear, Judge, this email I am referring to was in discovery, so it wasn't, I received it legitimately. If the court wants to see that paragraph or the whole email is fine. But the point being here is that this has been a strategy, a game of sorts, that the state has been playing, gambling that things would turn out the way they want rather than doing the test. Now that they've lost, they're trying to come back and do something again. They are trying to reverse it. That's evident from Mr. Gahn's own comments. December 6th is when they were notified, officially, that there was a blood vial in the clerk's office. No motion was made at the time. They wait a month to January 4th before they move to exclude it or to continue the trial for testing. Now he's telling us, for the first time, that when we were last discussing this, the court and counsel for the defense were told that the FBI would take about 3 months or 4 months or whatever it was going to be to retool and be able to do this test, because they do not even do EDTA tests anymore. They stopped doing them because they are not reliable. They haven't done them since the O.J. Simpson trial 10 years ago. They were going to have to recalibrate their entire chemical lab in order to be able to even do these tests for this case. Why? Because now the state is desperate. So now we hear, though, on January 10th, that Mr. Gahn was told, the U.S. Attorney is involved. U.S. Attorney's Office now says they're going to get the FBI to be able to do it. Well, did we have a motion on January 10th? No. Did we have a motion on the 11th, the 12th, or any of the succeeding days? No, because they gambled. They took a gamble that you were going to exclude the blood vial evidence, and they lost. They took a chance. It was a strategic decision the state made, and everyone has got to live with it. At this point, we've got jurors who have been on the verge of being selected. We've got everything ready for the trial to begin on Monday, and this trial cannot begin on Monday if there are going to be any tests, because, as I point out, State versus Wold, the Supreme Court decision in my motion, it is very clear that if scientific tests are to be done, the other side has a right to its own sequential tests, rebuttal tests. On page 4 of my motion, I quote from Wold, W-O-L-D. The need for full and fair disclosure is especially apparent with respect to scientific proof and the testimony of experts. This sort of evidence is practically impossible for an adversary to test or rebut at trial without an advance opportunity to examine it closely. We have we would have a surrebuttal right to present our own evidence debunking whatever the FBI comes up with here. Because as Mr. Gahn points out, every single reported case where EDTA has been tried, has been offered as evidence, has been the defense doing it. And the state has presented witness after witness, expert witnesses, to say that it is not reliable and it should not even be admissible, and they have debunked it. Now, all those witnesses we would have a right to bring into this court and rebut whatever they would come up with. But we can't do that now. It's too late because they took a gamble and lost. As I understand it, this EDTA test is the only thing they are asking for now, and the court has ruled on that. And there's no way at this point the court can reverse that without postponing the trial, which we object to. Mr. Avery is in custody. He has a right to proceed, and he should not be punished or prejudiced because of some strategy, failed strategy, foolish strategy perhaps in hindsight, but certainly a presumptuous one, to presume that this court was going to rule in their favor and exclude it in the first place. Especially when we see now that a full year ago, they knew that this was going to be an issue. They knew from the very beginning when he said it was planted. They have had plenty of time. This email proves that in February, they were talking about doing these tests a year ago and deliberately chose not to do that. So if these officers have to sit through a proceeding or news report that somehow makes them seem vile, I think that was the term, whatever, so be it. That's the strategy that the state took. That's the path that they took. That's where this trial is going. And it's a jury who is going to decide if they are good and decent people, solid, decent people, or not. The jury who hears the evidence as to that shows what they did or didn't do in this case will make that decision. They want to show the world that this blood in the rab did not come from the vial. That's absurd. They call the defense absurd. If they were able to do that, we would have been hearing about this long before today. Still, after 2 months, they have not been able to present the court with one single scientifically valid, reliable test that could be done at this point on the vial of blood that would somehow prove what they would love it to prove. It doesn't. There are no tests. There will be EDTA in the stains in the rab. There will be EDTA in the blood tube. There will be EDTA in the rab because, according to the state's experts in every other case, EDTA is a common chemical that is found in the environment, especially in cleaning products. Armor All, automobile type products. It's there. So there are no tests that I have heard either before court or in court or from Mr. Gahn. There are no tests that are going to prove what they want it to prove. That is, somehow, it's not like they are going to be able to do some perfect fingerprint or DNA type of test and say this came from the vial. This couldn't have come from the vial. For them now to wait, the Kunkel case, let me just talk about that for a minute. Kunkel says that the state can, in rebuttal, they can use an expert. That case was an OWI case where the state presented, in rebuttal, a blood alcohol absorption expert to rebut the defense that was presented, which is, I couldn't have been a .12 because I only had one drink. And several other witnesses were presented, said we saw him, he only had one drink. The defense objected when this witness came in rebuttal, saying this witness wasn't on the witness list. Kunkel examined the statute that requires disclosure of witnesses. It's 971.23(1)(d). That's all Kunkel did, and that does specifically say that there is an exception for rebuttal or impeachment witnesses. This is entirely different. This request falls under 5 of 971.23, which would be a motion for scientific testing. And as I think the case law is clear, that motion could have been made earlier and we would have had no reason to object or no right to object, because then there would have been time for sequential testing, for the defense to have a lab of its choosing, probably to call one of the state's former prosecution witnesses in many of these other cases to say this EDTA stuff is voodoo science. You can't prove anything. Yeah, we can test for EDTA, but it doesn't tell us anything. It can't prove one way or the other. And now, we can't do that if they are allowed to start testing now and suddenly spring it on us in the middle of a trial. It would require, I just point out to the court, look at that Cooper case. Look at how long, how many hearings they had, how many evidentiary lengthy hearings with experts and battles of experts that court had on that one issue. That's what we would be looking at here if we go through the trial. Suddenly, they bring up some test and they want to argue that it proves one thing when other experts will say, no, it doesn't. And we're going to have to postpone the trial, send the jurors home and come back in a few months. It's impossible. And I point out in 971.235, unlike the witness list statute, which does make an exception for rebuttal or impeachment witnesses, there is no such exception in 5. It doesn't say that you can present these in rebuttal, or you can hold off and put in tests in rebuttal, in the middle of a trial. And clearly, when you look at Wold and you see it's just common sense that the other side has a right to respond. And when you're talking about scientific tests, you can't just suddenly, after 5 weeks of trial or 6 weeks of trial, find an expert who's going to come in, look at this, test it, and be available to rebut it. It's just too late. And not only is it too late, the state has still, and this is very important, it's not like something is going to be kept from the world or something is going to be kept from the jury that would otherwise answer this question. There is no test that will prove whether this, if there was a test that would prove it, I would have asked for it, because then I believe it would show that the blood in the vial is the same blood that is in the RAV4. But I have done the research, and Mr. Gahn has done the research too, and there are no tests that will prove that, and that's why we haven't heard of any yet. So we're not holding anything back from the world or the jury by not doing these tests. Mr. Gahn points out Migliorino and talks about how the law is entitled to every person's evidence. And I think Nixon, United States versus Nixon, talks about that as well, but there are limits, of course. If either side were allowed to present whatever evidence they want, then we would be presenting evidence at the trial of other suspects that could have committed this crime. A number of them we could have presented evidence of. Instead, we have to go to trial and we can't answer the questions of the jury. Who did it if he didn't? We tried. We offered a number of witnesses, but this court ruled, under the law, as it was entitled to, that evidence should not come in. Similarly here, not every piece of evidence that either side wants gets to come in. There are limits on it, and this court has ruled on them already in this case. To do otherwise now would jeopardize a mistrial, having to retry this case all over, and simply because the state took a gamble and lost. So for all those reasons, I move to the court to deny this motion, with one exception, that we have no objection to being able to present fingerprints, a fingerprint test to the jury, whatever. I'm assuming that can be done in a way that won't alter the vial. They have superglue type things that are more or less invisible that won't detract from it. But we have a right to present this blood vial to the jury so that they can see it in the condition that it is, and then draw whatever reasonable inferences there are from that evidence. Thank you. The court. Mr. Gahn. Attorney Gahn. Very briefly, Your Honor. Very briefly, Your Honor. The timing was perfect in this case by the defense. They knew about this vial of blood at least in July, last July. And of course, Mr. Avery knew about it on January 2nd of 1996, when the vial of blood was drawn from his arm in the prison system. So I suspect they have known about this from the very, very beginning. They waited until December 6th to put this on us. It wasn't until the following week, I believe the 14th, that we actually all went and looked and actually determined that there was a vial of blood in the clerk of court's office. And as I explained to the court, too, there's no games here. This is too serious of a case. We don't play games here. To get the answers to the questions that I had over that Christmas holiday period was difficult. The professors at the universities, the science departments, the laboratories, and it wasn't until I brought the motion on January 3rd that we had the information that we felt was important to us and that we felt comfortable and confident that we would be able to present very valid, reliable scientific evidence to this court. As far as the email goes, and that we knew about a year ago, yeah, we did talk about it, but the decision was made, and the very reasonable decision was made, as is shown in the Cooper case. We didn't know there was a vial of blood in existence, and to test the stains in the SUV, we knew about how ubiquitous in nature the EDTA is. And it probably wouldn't have been helpful or wouldn't have told us anything. And that's the difference between all the cases and the facts we have here. Yes, the FBI does not routinely do this test because it's rarely, if ever, asked for by the state. This is a defense motion that they want to bring in. But here we have standards to compare it to. Certainly, it isn't like a DNA test, but in principle, it is like DNA. Certainly, it isn't like a DNA test, but in principle, it is like DNA. You can have the blood stains in the car, but it doesn't tell you anything unless you have a standard to compare them to. And we have blood stains in this car here, and we have a vial of blood that is standard. In North Carolina, at the lab, there's a standard that makes this just a vastly different case. I don't understand why they are so afraid of this testing. If their theory of defense is correct, I would think that they would also embrace this and welcome it. Don't they want to know whether the blood in the car came from the vial of blood? Your Honor, I believe that this case is so different that we will meet the Wallstead requirements in an admissibility hearing. The court has indicated, I believe all along, that it's willing to release that evidence to parties if they wish to test it. I think that the decisions that we made are reasonable. They make sense. And now that we know that this testing can be done and accomplished in the time frame that I was told it could not be, but for the assistance of the U.S. Attorney, the problem is that once that vial of blood is brought into the courtroom and jurors are being told questions, or to look at the vial and look at the color and look at the amount that's in there, that's still in liquid form, look at the top, look at the stopper, you are now getting into areas of science, and you are going to be, and without having answers in science, the jurors will be forced to widely speculate. How much was in there? How much was used at Laboratory Corporation of America? How much was there in the SUV? Is there more blood? It just cries out for us to have that opportunity to test it and to answer all these questions. And once and for all, put it to rest. And again, we will preserve one half of that, whatever is in that tube. They can do testing concurrently, and this belief that, they can't do anything about it now until they see our results is not true. They know the exact same experts that were called in the Cooper case. And I think everyone, and the court read the case, all the scientists that were called agreed on the underlying scientific underpinnings, the instrumentation, and the ability of the scientific chemistry labs, toxicology labs, whatever they are, to test for a particular substance using the instrumentation that they have now. The only question is the interpretation of the data. They know who those experts are. They can line someone up. The very second that data comes off to us from the FBI can be shipped to them, and they are ready to, they can move on this. They don't have to wait to see it and then look for an expert. They can find one right now. And if they want to do their own testing, whatever that may be, they can also do it right now. So I would ask the court, as I said, I believe the court has indicated all along its willingness to allow this testing. And I think that the most important thing here for the court to recognize is that once that vial is brought into the courtroom and is talked about in a scientific fashion, we must have the opportunity to answer those scientific questions. And again, I just cannot emphasize too much asking you to give us the chance to restore the reputations of these fine deputy sheriffs. That's all I have. Thank you so much. The court. All right. Attorney Buting. Judge, I have just the court. Go ahead. Attorney Buting. Response to that? Not a big response. We have still not heard from anybody, any expert, that will say that such a test exists that can restore the reputation of these officers or whatever. This is, Mr. Gahn is being disingenuous if he is comparing this in any way to DNA, where you can look at one, look at the other, and say, yes, there is a match. There is no such test. If there was such a test, we would have heard about it already. We would have had something presented. We would have an expert here today who would be opining, yes, we can do that. But we haven't heard anything. We're just hearing these wild assumptions that maybe there might be such a thing. They ask, don't we want to know? Wouldn't we like to know if there was? Well, we already know from all the experts we've talked to that there is no such test that can do that comparison. But if they want us to know so much, then let Mr. Avery out on bail. He's the one who's sitting in solitary confinement for 15 months while they made a choice not to test earlier when they could have. It's too late to do that now without postponing the whole trial. The argument that we can do concurrent tests is totally disingenuous because Mr. Gahn knows, as the court knows, there are no other labs that do this that are reliable or other than the one that was reputation has been battered in 2 cases, including the Cooper case. There, frankly, are no labs to do it at all, not even the FBI, until right now for this one test. So how are we going to find someone else to do it? We would have to go outside the country somewhere, assuming there is even anybody else anywhere who does. We can't do that. The court indicated a willingness to entertain some sort of testing, but I don't think the court entertained a willingness to reconsider the whole issue of whether we should allow an EDTA test. If there was some sort of easily done type of test that wouldn't delay the proceedings, that's what I understood the court's willingness to do. And that's what we would have been willing to do 2 months ago, if there was any such test. I haven't found any. Mr. Gahn hasn't found any. There are none. The answer is going to have to be left up to the jury in this case, as to whether the stains came from the vial or not. And nothing that could be done before, probably nothing even after, is going to answer that question one way or the other. And I think that's all. Thank you. The court. All right. Well, based on the developments as they have been presented to the court over the last few weeks, it's obvious that both parties regard the blood vial evidence, as it's been referred to, as important in this case. The information provided to the court, although there hasn't been an evidentiary hearing on the matter, is that the defense had some knowledge of the existence of the blood vial in the clerk's office last July, and the state indicates it was not notified of the existence of the vial until early December. Given the relatively late notice to the state, first of all, I'm not aware of anything that I would characterize as undue delay on the part of the state. From all indications, they were surprised to learn of the existence of the vial, and EDTA testing is not something that is as standardized, even as DNA testing, to the extent you can call DNA testing standardized. There's also a development of recent years. That's also a development of recent years. Ultimately, criminal trials are all about a search for truth. And at this point in the game, the court is not being asked to determine whether any test results from the blood in the vial are admissible, but simply whether or not the state should be given the opportunity to attempt to test the blood in the vial in order to determine if there is admissible evidence that will assist the jury. I think that it's only fair in this case to permit the state to be given an opportunity to do that. If there is probative evidence that can be derived from testing the blood in the vial, I think it's important to both parties that such evidence be presented to the jury, regardless of which party the evidence supports. So I'm going to grant the state's motion to have access to the blood vial evidence for testing. In the course of the arguments from the parties, there were a couple of things that became apparent to the court. First of all, the defense has a legitimate interest in determining the existence of any fingerprint evidence on the vial. And the vial will have to be secured in order to test for fingerprint evidence before any blood is withdrawn to do a blood sample. I also believe that the defense should have the right to have the sample split in the event the defense finds a lab that can do EDTA testing or any other testing that the defense may feel is meaningful in this case, so that they have an opportunity to conduct that testing. The court, in its previous ruling, refusing to continue the trial, commented on the difficulties expressed in the Cooper case with question of comparability. The court, in its previous ruling, refusing to continue the trial, commented on the difficulties expressed in the Cooper case with determining the significance of levels of EDTA in blood. But the Cooper case didn't address the question of comparability. In this case, it's alleged, as part of the defense, as I understand it, that the blood in the victim's vehicle may have come from the vial in the clerk's office. And the court is not prepared to say, and has been presented with no evidence to suggest that there may not be a meaningful comparison of EDTA levels in the blood vial and EDTA levels in the blood found in the victim's vehicle. So I think at least the potential here exists for admissible evidence. And until testing is done, the court simply isn't in a position to rule on its eventual admissibility. The only thing the court knows for sure is that if I deny access to the blood vial at this time, the court would never have a chance to consider such evidence. So I'm going to grant the state's motion on that basis. Attorney Buting: Your Honor. The court: Yes. Attorney Buting: If the court is going to do that, then the defense reluctantly moves to postpone this trial, to continue it, because otherwise we are being ambushed here. We will not be able to respond to whatever the state comes up with. It's just impossible. When you think about the undertaking that we have to do between now and the next 4 or 5 weeks, the number of witnesses, we're going to be in court all day long. We're not going to be able to respond to whatever it is they come up with. That's what Wold talked about. In fairness to his constitutional right to have a fair trial, there's no way that we can possibly prepare to rebut whatever the state comes up with. Now, it may be that what the state comes up with is favorable to the defense, but we don't know that at this point. That's the problem. And the only remedy, if the state does dig up some sort of evidence that they think is helpful to them and hurtful to the defense, The only remedy will be to adjourn the trial at that point. And with this kind of a trial, we can't do that. We will have taken a month's worth of testimony, and then we will be back in front of the court moving to adjourn. And you will be risking a mistrial and reversal of this case on appeal, because this man wouldn't have a right to rebut whatever the state is doing. It's that simple. The court. Response from the state, Attorney Gahn. Yes, Your Honor, again, they made this tactical and strategic decision last July not to tell us about it and wait until December. This is what their decision was, and this is what compel is all about, and what rebuttal evidence and rebuttal testimony is all about. I do take issue with their saying they can't do anything about this. There's plenty they can do, and this court has read that Cooper decision. We know who the experts are, and we know what the issues are. They can prepare right now, getting an expert lined up. I've talked to experts who said you can, once the data comes off from the FBI, send the data. It's not going to take long to look it over and say, is this valid or is it not valid? The issues are here, here are the interpretation of the data. No one is going to come in and question the underlying scientific principles here. They can start working on this now, lining up their arguments. And it will be the same type of arguments that were in the Cooper case. The ubiquitousness of this type of a chemical in the community and society and the environment. They can start working on that right this moment. And again, they can take their sample. There are other tests that I believe can be done that they could do if they wish not to do EDTA testing. Just the fact of, quantifying it. How much is in that vacutainer? How much did Megan Clement use at Laboratory Corporation of America? There are other things. What's the breakdown? We're looking into things, even the nature of, is there an irreversible effect of hemoglobin in the blood? At some point, does it turn a different color? These are things that they also, I'm sure, have been looking at and discussing among themselves. So I don't think they are not being caught off guard on this. We're giving them an awful lot of information. And I obviously will tell the court the very moment we get this information from the FBI, it will be sent to them immediately and as soon as we possibly can. And I will be checking with the FBI on a regular basis and hoping, can we get it? To get it as soon as we possibly can. The court. All right. I'm hearing different things from the parties today. I know in the defense's earlier argument, defense counsel, I believe, indicated that no one, perhaps, is capable of doing this testing, or no one at least other than the FBI. So if that would be true, the question could be asked, what would be the benefit of granting an adjournment after the FBI results came in, if nobody else is capable of doing the testing? And it's a little hard for me to accuse the state of ambushing the defense when the defense knew of the existence of the vial of blood in July, but didn't inform the state until December. Those comments aside, at this point, the court is not ruling on the admissibility of the test results. The court is simply being asked to give the state an opportunity to do the testing. And given the relatively late stage in the game in which the state acquired knowledge of the blood vial evidence, I believe it's fair to give them a chance to do so, and that's what I'm going to do, Mr. Strang, Attorney Strang. Well, the motion for continuance reluctantly is offered because, in fact, the court is being asked to do more than give the state an opportunity for testing. Tacitly, but unavoidably, when the question is EDTA testing, the court also is being asked to deny the defense an opportunity to do independent EDTA testing. It is true, I suppose, that we could go now, if we didn't have a trial to start on Monday, we could go and find experts who would testify in general about the reliability of EDTA testing. We could, in theory, do that if we weren't starting a trial on Monday. But the court well knows, and counsel has acknowledged in the hearing in Chilton to the court, that there are 2 labs, and 2 labs only in this country, that have ever done EDTA testing. One of them thoroughly discredited in North Carolina. The other, the FBI, which apparently is recalibrating and is willing to undertake that now. The only way, as we have discussed before, and as I think this court's decision recognized, the only way that we could do independent testing, as opposed to bringing in a catbird to criticize the FBI testing, would be to obtain from the FBI, if it will yield its protocols, obtain the FBI protocols, and then try to find a university lab with an analytic chemist who is willing to try to follow the FBI protocol and undertake independent testing, assuming that that university was equipped with the same gas chromatograph or infrared spectrometry machine, or whatever the FBI uses. I have no idea what the protocol is, and indeed we were given to understand that the FBI is recertifying and re-examining its own protocol. So there's no way to do defense testing here at a reputable lab or with reputable scientists other than sequentially none. And it is therefore a motion to deny the defense a chance to meet with independent testing the state's rebuttal offering. And I understand the court's ruling and the impulse to say, eventually this is going to get tested, so let's have it out. Let's thrash it out. It's admissible or it's not. It helps the defense or it helps the state. I understand that. And as I have said from the beginning, if I didn't have a client in custody, I would have joined the motion for adjournment. I'm curious too, and I realize that as a practical matter, someday the blood vial is going to be tested for EDTA. Partitioning the sample is not in itself prejudicial. We have acknowledged that. The testing is going to be done someday. But when it's done during trial, with nothing more than a promise, heard today for the first time that no, it's not 3 to 4 months, we can get the results from the FBI before the end of trial. The necessity here on this test for sequential testing means necessarily that we are being denied the opportunity to do independent testing. That's a due process right and a fair trial right that Mr. Avery has, and forced to choose between sitting in jail for another 6 months or whatever it is and a fair trial, forced to that choice, I guess we will take the fair trial and due process. And that's the specific problem here. I'm not worried about fingerprints or viscosity. Once EDTA is the rebuttal point, then the surrebuttal point also is EDTA. And that may require independent testing. And independent testing on these circumstances cannot be done until we have the FBI protocol and an opportunity to find somebody willing to get into that business who hasn't been discredited as a charlatan and a fraud, as have the people in North Carolina. So yes, it's a reluctant motion for a continuance, but we don't have a realistic choice. The court. Anyone from the state wish to be heard? Attorney Gahn. This would have been a wonderful conversation to have last August. That's all I have to say. The court. Well, the court denied the state's motion for a continuance in part because I ruled that if the state had wanted to do EDTA testing on the blood found in the victim's vehicle, it could have been done so earlier. I think the defense is somewhat in the same boat here. If they wanted to do EDTA testing on the blood in the vial, efforts for that could have been started earlier. If it's possible, and I understand the defense may be telling me that there is no other lab other than the FBI that does such testing now, and maybe there will be one that does some someday. Maybe it will be 1 year, maybe it will be 2 years, maybe it will be 5 years from now. But I don't think the court can simply postpone the trial to some point indefinitely in the hopes that someday There may be another lab that can do EDTA testing to double-check whatever results the FBI comes up with, if the FBI comes up with any results. So as I indicated, I'm not going to preclude the state from taking a chance at attempting to test the blood in the vial simply because of possibilities that may or may never come about. Attorney Strang: Your Honor, once again, I don't have access to the FBI lab. I couldn't get going on EDTA testing earlier, couldn't if I wanted to. The defense has no access to the FBI lab, and the FBI is the only organization in this country, and I don't think Mr. Gahn will disagree with that has a protocol for doing the testing he wants to do. And, the insinuation that we were late overlooks the fact that we beat by 9 days our deadline for disclosing exactly this type of information, and also overlooks the fact that this was in a public record that anybody in the world and apparently a bunch of different media organizations walked in and looked at from 2003 on. So, we really are in a position here where we are being denied a fair trial and due process opportunity to do independent testing on the facts that this court has in front of it here. I don't have a choice but to ask for a continuance and to object throughout here that we haven't had a chance to meet the state's proposed rebuttal. The court: I don't know if the state has weighed in yet on the request for a continuance. Let's do this. I'm going to take a 10-minute break, since I don't think that request was known to anybody until now, and then I will hear from the state, if the state wishes to be heard after coming back. Attorney Gahn: Thank you, Judge. Recess taken. The court: Does the state wish to be heard on the defense motion for a continuance of the trial? Attorney Gahn: Your Honor, I understand what the defense is saying, that, at one point we did ask for a continuance, and we did. But at that time, we were under the impression that the testing that we want done could not be completed in time. And that is why we asked it. And now, with the assistance of the United States Attorney, we are able to get that testing done in sufficient time. I truly believe, and if I felt that there were anything unfair about this, I would tell the court and be candid. But I feel comfortable enough stating that I think they can prepare for this EDTA testing. They know who the experts are. They know who around the country, where they can go to. I just think that they can adequately prepare for these test results. I will tell the court I will do everything I can to get whatever materials I can to them early on. I will start making my calls, if not today, on Monday. And I will try to get as much material about the FBI and their protocol and their operation and get it to them as soon as I possibly can. But we believe that we are ready for trial. I believe that we owe it to the Halbach family to get this trial going, underway, and complete this trial. So we do not join in any request for any continuance of this matter. The court: Mr. Strang? Attorney Strang: Perhaps the court would be kind enough to put one very direct question to Mr. Gahn, who's the acknowledged expert on scientific testing and EDTA testing in specific here. And that question is this: Is Mr. Gahn aware of one credible laboratory that presently, today, can do EDTA testing of the exact sort he proposes to do, other than the FBI? The court: Mr. Gahn? Attorney Gahn: No, Your Honor, but I will say this much. They are making it sound like this is something that is so unusual. The FBI doesn't routinely and normally do this, nor does, first of all, because it's rarely asked for by the state. Also, I suspect private laboratories do not engage in it because there's probably no money in it, because it's so rarely asked for on any occasion. That doesn't mean that a university research facility or any other laboratory that has the machinery and instruments or gas gas chromatograph, and all the instruments wanted, cannot ramp up for this test and retool their equipment. That's my understanding. Someone can. You can analyze any elemental substance. Any chemical, basically, can be analyzed with the instruments at any lab or research facility that a university has. That's my understanding. You know, Your Honor, you see cases in the newspaper about someone suspects that someone was poisoned by some unique poison, this one recently in Britain or something. I'm sure that some laboratory had to ramp up and retool or something to test for this specific chemical. This isn't something that's so bizarre or unusual. This is normal chemical substance analysis by any laboratory. Attorney Strang. So this is where the court finds itself on a continuance, and as I understand it. Until an hour ago, all of us were under the understanding, that is, the court and the defense table, we were under the understanding that even the FBI, which has done EDTA quantitation testing in the past, would need 3 or 4 months to do it. Now we're told that before the end of the trial. So presumably sometime between now and the middle of March, through the fortuitous intervention of the United States Attorney in Milwaukee, the FBI can speed up the earlier timeline that all of us were given. I have no statutory right to call on the FBI. Neither can I expect the United States Attorney or anyone else to help me find a lab that has never done this sort of testing to do it in 6 weeks or 5 weeks, let alone the 3 to 4 months that even the FBI initially was saying it needed. There are exactly 2 lawyers representing Mr. Avery. Both of them will be in Chilton 5 days a week beginning on Monday. And the court also will have to entertain, before we can do any testing, a motion under AKE versus Oklahoma. Because I expect that it is likely, it seems to me, and I have not checked this, I haven't gotten quotes, but where you are asking somebody to spool up from the start to do independent testing that they have not done before, once they get FBI protocols, I suspect that the cost of that will be well beyond the cost that my firm can bear, because this isn't coming out of Mr. Avery's pocket. Long ago were his resources exhausted, and so the court will have that due process consideration under AKE versus Oklahoma to consider as well. Although the process of getting quotations and casting about North America for universities that might be willing to get into this business, in theory, could begin were we not at trial. So that's where the court finds itself functionally. We are being denied here to do independent testing on EDTA or its quantitation. I object to that on constitutional grounds, fair trial, and due process. A continuance of some months would remedy that. There's the issue of Mr. Avery's right to a speedy trial and his custodial status. Perhaps that could and should be revisited, because it was, after all, the court's reliance on the new charges and the amended information that caused this court, in large part, as I recall, to raise the bail by $250,000 last spring. And now, of course, the most serious of those 3 new charges and the amended information are no longer. And perhaps what goes around comes around on that. But that's not for today. What is for today is a reluctant request on due process and fair trial grounds on the record we have made for a continuance and an opportunity, realistic opportunity, to assess the FBI results, to meet them, to have an evidentiary hearing under Wallstead on the admissibility of those results, whether they are favorable or unfavorable to the defense, and to do independent testing as by our best lights in the defense of Mr. Avery and in presenting his case, as the court has allowed it with the contours of its ruling, to a jury so that he will have a fair trial the first time. And those are the basis for my motion for continuance. The court. Anything else from the state? Attorney Gahn. No, Your Honor. The Court. Well, as I indicated earlier, the Court feels it's getting conflicting messages here about the extent to which anyone, other than the FBI, can do the testing. If it can be done within a matter of a few months, it seems to me the state, or the defense, has known of the existence of the blood vial since last July. And I'm not sure I fully understand at this point why the testing could not be done. It appears that the defense is asking to do the testing in response to whatever results the FBI might come up with, but in any event, the defense did not disclose to the state the existence of the blood vial until early December. With that timeline, the Court finds it unlikely that the results of the FBI testing would have come before today, or at least much before today, soon enough before today to give the defendant an opportunity to do other testing, if it's even possible. And if it is possible, and if the Court splits the samples today, each party would have the same opportunity to have the same amount of time to get test results in. So I'm not going to adjourn the trial. I am going to grant the state's motion for access to the blood vial. The one item that I did not address originally, I indicated that the defense could have a split sample of the blood in the vial, that the vial would have to be tested for fingerprints before any analysis of the blood was done. I do not know if the defense at this point has enough photos of the vial for whatever the defense may want to show with respect to the vial as part of its case here. Attorney Strang. We could use more photos because, of course, the vial, when it's shown to the jury physically, will be missing, presumably, about half the blood that's in it now. You know, the state, in a cocaine delivery case, doesn't go forward to a jury on photos. It brings in the cocaine. In a felon in possession of a firearm case, the state brings in the gun. We're functionally allowed to bring in only the altered vial to show this jury. We have argued in the motion, or in the response that Mr. Buting filed, which again goes to fairness of the trial. The next best alternative is to take good photos showing the current quantity of the blood and video footage, or moving footage, showing that the blood is in a liquid form today. So that would be our alternate request, without abandoning any of the arguments that I have just made, of course. And then there's also the matter of the blood spot cards that the Court has not yet addressed. Attorney Buting. Judge, I just want to clear up the record at one point, because you said you have been getting conflicting messages. What I want to make clear is, whenever we discovered that there may have been a blood vial in the court file, there were no labs anywhere that we could find that would test this. So it's not like we made a decision not to test it. Mr. Gahn will concur with that, because other than this one Ballard lab, there was no, which was considered disreputable by all the reported courts. There were no other labs doing this test, including the FBI. The FBI is only doing this test now because of this case. So I just want to make it clear that this wasn't some strategic decision we made not to do the test. There was nobody we could go to, the Court. All right, how can the photographing of the exhibit suggested by the defense be accomplished and still allow the vial to be made available for testing? Attorney Gahn. Well, I do know that they took plenty of photos when we were all together down in the clerk's office, also had a film camera and took moving pictures, also, of the vial and still photographs. Let me just back up a moment and make this suggestion. I would ask the Court to rule that the fingerprinting of the vial and the styrofoam box and cardboard box be accomplished. But I would ask the Court to leave that to the discretion of what order it would be done with the FBI analyst. The reason is this. I don't want any type of super glue, any type of fuming used that perhaps may interfere with the chemical testing that will be done. It may be prudent, and the FBI say, look, we would rather get the blood out of the vial first and would do it all gloved and then to do the fingerprinting, so as not to interfere with the chemical analysis. I don't know the answer to that, but I would ask that your ruling be that fingerprinting be accomplished and the order of it be left to the scientists. The court. The FBI is going to do the fingerprinting? Attorney Gahn. What I was thinking of doing was that the FBI is going to be doing the packaging of the vial for us. I was going to have one of our officers involved in this to be present and take custody immediately of the cardboard box and the styrofoam box, and then the actual fingerprinting of the vial I would ask the FBI to accomplish, when they think it is the better time to do that. And that's how I would like to see the order be. The court. If the defense is allowed on Monday to take whatever photos or video of the vial it wants, you can have it on Monday. Would that work? Attorney Strang. How do we do that? Attorney Gahn. Judge, we'll make it work. We would prefer to take it. I will tell you this. I will ask the FBI, and I would hope, they have never denied other requests before, would they have their photography unit make very, very good still photographs of it for us that I'm sure would be better than any of us could do. I would ask that be accomplished beforehand, once they get the vial. I will ask that. I don't think they will deny that. If they do, then we'll make other arrangements. The court. Mr. Fallon. Attorney Fallon. I may have a moment with counsel. The court. Go ahead. Attorney Gahn. I have just been informed that we have available video camera that could make available to them this afternoon, and they could take all the pictures they want of the blood vial this afternoon. The court. I know the defense has some photos already. Attorney Strang. Yes. The court. I'm not sure what else is. Attorney Strang. We do have some photos already, not intended at the time to be a replacement for having the physical evidence at trial. This is an exhibit handed over to a party, and the jury won't have it. So that's been the court's ruling, and the next best alternative is to allow us to photograph with the idea of alternate evidence being offered to the jury, video, and still. I object to fingerprint testing being done after this vial has been handled for testing, and there's an obvious spoliation problem with destroying or smudging fingerprints that otherwise may be identifiable. But again, a court exhibit is being turned over our objection to the other side. And now a course of action is being proposed that presents the real risk of spoliation of fingerprint evidence. The court. Well, what opportunity to photograph or video the exhibit is the defense requesting? Attorney Strang. Before it goes, we need a chance to photograph it still and videotape it. I'm not sure what video equipment the state has. I'm not opposed to using their video equipment. I know we're in court this afternoon and we're starting a trial on Monday morning, so. Attorney Gahn. Is there access to this building on Saturday or Sunday that they could do it? The court. I'm sure there could be. Attorney Gahn. Could we work that out? Attorney Strang. Your Honor, look, I'm moving from Madison up to trial tomorrow, and I'm starting trial on Monday. I'm not anticipating, nor do I have time, resources, or personnel to be arranging for trips to Manitowoc the weekend before a trial. Attorney Gahn. Your Honor, may I just have another suggestion? How about this? How about release it to our representatives here from Calumet County Sheriff's Department, and DCI will take it back to Calumet County, where they have an office set up and where they will be this weekend, and they can do their photographing at the Sheriff's Office in Calumet County this weekend. We won't open it. We'll wait until they are present, and they can photograph it from taking it out of the cardboard box and then opening up the styrofoam box and photograph there. The court. Who's going to be doing the photography work for the defense? Attorney Strang. I have no idea. Probably one of the two people here, unless we can get our defense investigator, and I don't know his availability for this tomorrow. I didn't expect this. Attorney Fallon. Your Honor, we would note that there was an extensive video shot on December 14th So this would be an adjunct or a supplement to previous video and photographs. The court. Well, everybody's going to be back here on Monday. It's perhaps unfair to the defense if they weren't planning on doing this photography today, which they may well not have been doing. So I will give them until the end of Monday to make arrangements to do whatever photographing or videoing of the exhibit they wish, and then I will release it. Order it released to the state. Attorney Gahn. Your Honor, would you just, to conform your decision with the written order, that this also includes the spot cards that are in North Carolina? The court. Actually, I haven't heard anything about the spot cards. I don't know if there's an objection to those. I frankly don't know what they are because until your motion, I didn't really hear them referenced to. Attorney Gahn. If the original testing was done in 1996, my understanding is the blood was drawn from Stephen Avery on January 2nd. And on January 4th of 1996, Laboratory Corporation of America received the blood vial in question. They did the initial Innocence Project DNA testing and came up with inconclusive results. As part of their testing protocol, upon receipt of a vial of blood, they open up the vial and they put it on what are called spot cards. Spot cards preserve the blood sample as best they can, and that is what they do their testing from, these spot cards. My understanding, there's a number of them. When I talked to the FBI, they thought those would be helpful in interpreting the EDTA data, because here you have samples of that blood vial which were taken 2 days afterwards. Presumably, Laboratory Corporation of America has maintained them better than a liquid blood vial sitting in the clerk of court's office. These were maintained in a different setting, and one could see if there's any type of degradation to them, and they would be important. The court. So the blood from the cards came from the vial that's downstairs in the clerk's office? Attorney Gahn. Yes. Attorney Buting. Judge, maybe I'm misunderstanding the theory here, but if the blood that was in the vial is what was used to plant, or was planted in the vehicle, then the relevance will be what's the EDTA in the vial, not what it was 11 years ago. I don't see how that's going to have any relevance to this test. The court. Well, at this point, given the fact the court is not an EDTA expert, frankly, I don't know what relevance it has, but I'm not being asked to rule on its admissibility today. The court is just being asked to allow the defense to test it. Attorney Strang. No, the state, the court, or the state to test it. And I can't think of a reason not to allow that. Attorney Strang. Well, if you want the defense to be heard, Laboratory Corporation of America was a defense-hired consultant in 1996. This was defense testing done at the defense request, not jointly with the state. So what we're being asked now is for the court to order, on the 1985 file, that defense expert in North Carolina be required to yield to the state of Wisconsin work product that was done at the defense request and at the defense expense at the time, so that the state and the state alone can do EDTA testing here to the exclusion of the defense. It's probably not relevant given what's been ordered so far. I'm not inclined to stand in the way of the march of knowledge, but again, this is just sort of a power play and a grab for a chance to do testing that we won't be able to repeat or meet or consider doing independently. I think the record, including on January 4th, 2007, really is very clear about the fact that there is presently, today, no one in the business of doing EDTA testing that the state apparently is prevailing upon the FBI to do for it, and it only. To preserve, our options, whatever they may be, long after this trial is over, I suppose, if the court is going to order defense to give up work product of a defense expert, then, and, also order that half of those spot cards be preserved inviolate, in the hope that someday there will be money and time and another lab to do the defense testing and prove that the state's tests shouldn't have been considered in isolation at this trial. The court. How many spot cards are there? Attorney Gahn. I don't know, Your Honor. I believe there are more than one. And when I read the laboratory notes, and although Mr. Strang is portraying this as work product, this was by order and by stipulation of the parties, and as my understanding when I read it was, Attorney Strang. Nope, the testing was not. The withdrawal of the blood for the purpose of defense testing was by court order of Judge Hazelwood and by stipulation of the state of Wisconsin. The testing was not joined. That's simply the fact, as I understand it. Attorney Gahn. But again, that case is over with now. It's a public record. And I do believe that we did prepare an order for Judge Fox to ask him to relinquish whatever jurisdictional control he may have over it. We're prepared to go to that court and ask him to sign that, and that you be given the authority to make decisions on the blood evidence. Attorney Strang. And to that, we don't object. But the blood spot cards are not a public record, never have been. It's defense work product. We object to the whole road on which the state and the court have embarked today, this included. The court. Well, I would agree that the spot cards, as they have been characterized for the court today, are different from the blood vial in the sense that it's not part of the court record. What I don't understand and what I'm not sure the parties have addressed is the significance of that. And when I say that I have not ever been requested before to issue an order that the contractor of the defense, if you will, turn information over to the state. It's not the same as simply ordering that something in a court file be released. Attorney Strang. But, the position we're in here, of course, is that if we don't agree to it, the state eventually convinces this court to allow the FBI results, with no opportunity for us to rebut them. Then we will also hear testimony that we tried to prevent the FBI from having access to something that might have been relevant to its testing. So, the court. I don't think the court would allow that if I didn't order the information disclosed. I'm not sure. I don't believe that would be proper for a jury. Attorney Gahn. I guess I would quote, again, from a Migliorino case that I cited before. This is every man's evidence, and the state and defense is entitled to it. This is going to be important evidence. The court. I think, though, that the defense is entitled, and this is difficult without knowing how many cards there are. The defense would be entitled to retain some for their own purposes, either at this point or some point in the future. That doesn't seem unreasonable request to the court. Attorney Gahn. I suspect that if there's one spot card, I would request her name is Megan Clement, who is in charge of the forensic unit there, cut it in half. We'll preserve one half. If there are 2 spot cards, we'll take one and save one for the defense. The court. I'm going to want to know more information about the spot cards before I rule on that part of the request. So I'm not going to rule on that part today. Attorney Gahn. Okay, the court. I will just rule on the blood vial. Attorney Gahn. So are we waiting till Monday that we can take the blood vial? The court. Yes. Attorney Gahn. Monday afternoon or upon their completion of whatever? The court. Yes. Attorney Gahn. Okay, thank you, Judge. We'll prepare another order.